The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your weekly podcast on the Federal Courts of Appeal. I'm your host, John Ross, joined today by Clark Neely and Evan Bernick of IJ's Center for Judicial Engagement. If you like what you hear, be sure to subscribe to our weekly email roundup of circuit court decisions at ij.org/shortcircuit. This week on the show, illegal incense, hydroelectric power, and your right to an attorney. Clark, kick us off.
So the first case comes out of the 10th Circuit, involves an interesting question under federal law. It's a drug law, and it's called the Analog Act. It's part of the Controlled Substances Act, or it's an extension of the Controlled Substances Act. It basically attempts to criminalize when people come up with a synthetic drug that is similar to an illegal drug, but it is not marijuana, or it is not methamphetamine. It's a synthetic drug that is similar enough that the federal government wants to criminalize it. And this case presents a challenging question of how similar does the drug have to be, and what elements does the government have to prove in order to convict somebody of violating the so-called Analog Act when they sell, an intoxicant that is similar to but not identical to a drug that is listed on the Controlled Substances Act. That issue comes up in this case, along with some really appalling government shenanigans in terms of what they did in securing a conviction of these two individuals who ran a convenience store that sold some of these drugs.
Evan, why don't you tell us more about those individuals?
Yeah, so this case got started when questions surfaced about the incense that these two guys running this convenience store were carrying on their shelves. They spoke with state law enforcement officers, and they even offered to have the officers test the incense to determine its legality, and offered to even stop selling it. That didn't...
offered to stop selling it while it was being tested to see whether it was...
While it was being tested, right. And while that cooperation won them little admiration, they found themselves indicted and they found themselves convicted.
Well, wait a minute, let's be clear again. It won them little admiration with the federal law enforcement authorities who were also investigating them. So in other words, they agree to cooperate with state law enforcement authorities, but the federal law enforcement people just don't care about that at all.
Right. And the government argued at trial that there are two components to the Analog Act, what you have to do to be convicted under it. You need to have knowledge that it possesses chemical components. The substance that you're selling possesses some similar components to proscribed controlled substances, and that it has a similar effect on individuals. And the government argued that because these guys knew that it had a similar effect on people to drugs that are actually illegal, then they must have also known that the chemical composition of the drugs was identical to those of controlled substances.
Or substantially similar,
or substantially similar.
Which is the statutory term. So in other words, what the government did was it tried to take two independent elements that it has to prove. In other words, that first, you know that the drug you're selling is, quote unquote, substantially similar in its chemical structure to a drug that's listed on the Controlled Substances Act, and two, that it produces a similar effect. What the government did in this case was say, oh, well, you guys knew that this drug you're selling produces a similar effect to marijuana, so you must also have known that it had a substantially similar chemical composition. That argument was accepted by the district court, even though it is absolutely ludicrous on its face. As the 10th Circuit points out, it would be like saying that just because Advil and aspirin give you similar relief from a headache, they must be substantially similar in their chemical composition, which they're not.
Right. And not only that, the very fact that these people came forward and said, go ahead and test these things, suggests that they didn't have knowledge that the chemical structures were similar or even identical.
Yeah, and it's important to note here that the government actually filed a motion in limine with the specific point of excluding any testimony that the two defendants, the convenience store owners, had cooperated with state law enforcement in trying to get the drug tested. As a 10th Circuit, to its credit, Judge Gorsuch's opinion is absolute pleasure to read. It's so lucid and so logical. But as he points out towards the end of the opinion, it is difficult for us to imagine why the government would have opposed the introduction of this evidence and taken the trouble to present a written motion on that score, but for its extraordinary power to persuade the jury on the questions at issue, namely whether the defendants had the requisite mens rea. In other words, the government tried to exclude the evidence of their proffered cooperation with state law enforcement precisely because it was so probative in the defendant's favor. A really, really disgraceful performance by the federal prosecutors in this case. One despairs of them there being any accountability, of course, because there doesn't seem to be any within the Department of Justice. But this was a really disgraceful act on the part of these prosecutors. They tried to get this evidence excluded precisely because they knew how persuasive it would be to the jury, and good for the 10th Circuit for picking up on that. Evan wanted to make one more point about another ridiculous example of prosecutorial overreach in this court that almost is so ridiculous it makes you laugh.
Right. You actually had a government witness testifying that the one of the substances in question caused the death of a friend who was actually alive and prepared to testify in that very trial later in the day.
So just to be clear, the government calls a witness who testifies about how bad this drug is by saying, "Oh yeah, it killed my friend," well, knowing the government now knows that they're going to call the friend later in the afternoon, who is apparently not dead from the drug. So this is an example of the tremendous overreach and irresponsibility of the prosecutors in this case, seemingly trying to get a conviction through any by hook or by crook. And that perhaps prompts the court to drop a footnote, which it does on page 11, and raises apparently sua sponte the possibility that double jeopardy might prevent the prosecution of the defendants the second time when the court is remanded to the trial court. Almost seems as if the Court of Appeals is suggesting to the trial court to go ahead and take a look at this double jeopardy issue, and perhaps also signaling to the government that it may be time to drop this terribly botched and probably unfair all along prosecution.
Right, and the other point that to really keep in mind here, it's not just the prosecutorial abuse that's the problem here, it's the passivity, the abdication on the part of the district courts to put a stop to it, to recognize that the government is trying to pull a fast one and to call it out. Thankfully, the Court of Appeals engaged, and it got to the correct result.
Okay, let's move over to the D.C. Circuit now. Clark?
So the next case is an administrative law case that raises a kind of an interesting question. When Congress enacts a law that seems to be nonsensical and or outdated, but sets forth the policy in unmistakably clear terms, do administrative agencies have the authority to sort of rewrite the law to try to make it make sense? Cutting to the end of the case, the answer is no. But what's at issue in this case specifically is a provision in the Federal Power Act that requires the Federal Energy Regulatory Commission, otherwise known as FERC, to grant a preference in issuing licenses to operate power plants to municipalities. And the issue basically is there any geographical limit on this requirement? So, for example, if a municipality on the East Coast, let's say Boston, wants to apply to operate a power facility in Hawaii, does the municipality of Boston get a preference to operate that facility as opposed to a local private operator on the island of Hawaii? That's the issue that came up in the case.
So, Evan, that seems kind of silly. Why do we have a preference for a public operator as opposed to a private developer running a power plant?
I mean, it doesn't seem to make a lot of sense. If you look at the law, it was enacted in the 1920s. It's an old progressive era policy, and it may well be poorly designed bad policy. But the essential point to keep in mind here, and what the court properly keeps in focus, is that executive agencies are supposed to be executing the law. They are not supposed to be improving it and amending it to make it serve what they think are useful purposes. And the court in this case focused on the text of the statute, what it specifically authorizes the agency to do, and refused to allow it to evade the clear text of the statute in the name of what it thought was sensible, right, and reasonable.
Yeah, I mean, I think there's a good argument for let's have the country, we should be stuck with even the bad policies that Congress enacts when they enact those policies and do so clearly. This brings to mind, of course, Obamacare, which appears to be entering a death spiral. It was a clearly enacted policy. The Supreme Court stepped in a number of times to rewrite portions of it to make it more viable. It appears that even that wasn't successful. But a strong argument can be made, and this case kind of helps to illustrate the point. Leave it to Congress to write the policy. The executive agencies should enforce those policies when they're clearly expressed. And if they turn out to be bad policies, as this one almost certainly is, giving municipalities from far-flung regions a preference for operating local power plants, then it's on Congress both to take the consequences of that bad policy and hopefully to be more careful in the future.
Yeah, and an argument can be made, and I'll just make it now. To the extent that we have a system that's designed to ensure that the laws that are on the books are made by people who are effectively accountable to the people, we shouldn't have a situation where, in the name of executive officials' interpretations of what they think are just and reasonable, the people who are ultimately accountable directly to the people are effectively left out of the democratic loop.
Okay, let's move on to the last case. Evan.
So this is actually a fascinating case. It involves a prisoner who's bringing claims arising from what he alleges are unconstitutional conditions in the place of his incarceration.
Which is far-flung West Texas.
Yes, it's far-flung West Texas. This is a privately operated prison, and he's bringing claims arising from the conditions there. He says that they're unsanitary, that they're overcrowded. There are a number of plausible complaints that he has. When he brings these claims, he is denied access to evidence that's relevant to assessing just what the conditions in the prison were, how it was structured, and the judge in this case ultimately says, look, you are not in a position to be able to effectively cross-examine prison officials, and you don't have access to evidence. You need a competent attorney. You need a lawyer to help you. But because there's no lawyer available, the judge effectively says, you're out of luck, and there's nothing we can do for you.
Clark, tell us a bit more about what he means about being denied access to evidence.
Well, in this case, among the things that the pro se prisoner wanted produced were schematics and drawings of the prison facility, presumably so he could sort of help demonstrate that some of the policies of the prison put you in a difficult position. For example, you could either go out and exercise where you would only have access to really unhygienic toilet facilities, or you could have access to hygienic toilet facilities, but only if you stayed inside the whole day. And presumably he wanted access to some of these schematics and drawings to help demonstrate the layout of the prison and show how prisoners were being put in that untenable position. The prison initially refused to produce this information on security grounds. The judge ordered that it be produced under seal. It's not important to get bogged down in the nitty-gritty of the discovery battle, only to emphasize that there was a discovery battle, a very challenging discovery battle, and the merits of the case are challenging as well. Clearly, as Evan pointed out a moment ago, this guy needs an attorney in order to effectively represent himself, and he's making a game effort of it. He really is. But he makes it clear to the court he's just not qualified to be an advocate under these circumstances, and he needs somebody who knows how to do it.
And the district court agreed, the magistrate judge agreed, did he not, Evan?
Yes, he agreed that that exceptional circumstances justified appointing this guy an attorney because there was no way that we were going to get to the truth of the matter if he's relying upon his own competence. I mean, the guy's not a dumb guy, and he knows a little bit about civil procedure, but he doesn't know enough for the court to have confidence that you're going to get to the truth of the matter and the merits of his constitutional claims.
And yet he wasn't assigned an attorney.
Yeah, the problem is the court notes that it doesn't have any special fund to pay for the appointment of an attorney in a civil case. And when it turns to the lawyers in the jurisdiction, it's Pecos, Texas, which is out, as Evan pointed out, kind of in the middle of nowhere in West Texas. None of the local attorneys will agree to take the case pro bono and represent this prisoner. And so the district court judge essentially says, well, my hands are tied. There's nothing I can do. The question that comes up to the Fifth Circuit is that really true? Were the district court judge's hands really tied? Was that the end of the story? Or is there something more he could have done? And of course, there is one more thing he can do, which is to order one of the attorneys who is admitted to practice before this court to take the case pro bono. That's the question that went up to the Fifth Circuit.
And what did the Fifth Circuit say?
The Fifth Circuit said we are going to compel a lawyer. We are going to rely upon our inherent powers to assure that, in the rules of the federal words of the federal rules of evidence, that the truth be ascertained.
And to be just more precise, what the Fifth Circuit panel says is that as a matter of last resort, the district court has the inherent power to compel an attorney who is admitted to practice before that court to step in and take not just criminal cases, which really stands to reason. Of course, courts would have the power to ensure that a criminal defendant has an attorney. And what the Fifth Circuit says is apparently as a case of first impression, that power extends equally to compel representation in a civil proceeding as well.
Right. For the same reason that we don't think that a layman is competent to handle himself, and we're not going to get to the truth of the matter in a criminal case, we're confident that a layman is not going to be able to handle himself well, and we're not going to get to the truth of the matter in a civil case if discovery is sufficiently complicated, if you got to cross-examine a bunch of witnesses, and if the evidence in this case is under seal and you don't even have access to it in the first place. Our commitment to the administration of justice and the ascertainment of the truth is strong enough that we will compel a lawyer to ensure that this person gets a fundamentally fair proceeding.
Yeah, I mean, look, Congress chose to create a cause of action for prisoners that, in certain circumstances. And the question becomes, do we permit the failure or the refusal of local attorneys to accept a representation to essentially render that legal remedy that has been created by Congress a nullity by simply saying to people, hey, listen, if you're not very good at litigating, well, I guess you won't be able to vindicate your rights. That really does seem to be an intolerable result, but it was a result apparently that the district court was prepared to allow.
But we had an engaged decision by the Court of Appeals. Makes us 3 for 3 in judicial engagement this week. Bravo.
Okay, that concludes the show. Thanks for listening. For more cutting-edge commentary on judicial engagement, check out Evan's columns at the Huffington Post. To find them, Google Evan Bernick and Huffington Post. Until next time, this is John Ross from the Institute for Justice, provoking you to get engaged.